Now, we're here today with our top scholar, Tom Donnelly. Tom, you want to say hi to everybody?
Hi, everyone. Great to see you. Can't wait to get started.
We have so much to talk about, but I wanted to tell you a few things really quickly. Number one, we did this amazing briefing document for all the court cases because we couldn't pick just 5 to 6, which is what we're going to get to today. We were picking, I think we have a 10-page document. So there's lots of amazing cases in there. So we made this. I'll send you the link in the chat in a second. Check it out. Look at the questions, the big ideas. It's an awesome resource. And we wanted to make sure you could have fun today and ask questions and not worry about taking notes. But today we're going to look at these landmark cases. And just to remind ourselves, what is a landmark case? These are major cases that the court that we have studied because of their historical or legal significance. And the most significant cases are those that have held a lasting effect on the application of law and concerning our individual rights and liberties. This is what we mean by landmark cases. And we study these cases so we can understand how the courts work over time, how they affect our lives, and how they can affect future court decisions. Now, Tom, we threw another word in here, canonical cases. So can you share with everybody what is a canonical case?
Sure. The way I think about canonical cases they are landmark cases that are really still good law, that they're good, we still follow them. They could be models of great constitutional arguments. They could just be they might provide legal tests that we use today. Or they just may represent broad constitutional values that we think are really, really important and enshrined in the Constitution. But they become canonical precisely because they are they're the great ones, is the way I would think of it.
Awesome. So we're going to start off with some great ones. And so we broke this up into 6 different sections. And so we're going to start where we always start, in the basement with the foundations, keep our America strong with our foundations. So 2 big court cases, Madison and McCulloch, Marbury versus Madison and McCulloch. So Tom is going to do these 2 with a lightning speed. Go.
All right. So Marbury versus Madison, let's start there. These are 2 big cases from the Marshall Court, Chief Justice John Marshall. Marbury is really about establishing the Supreme Court's role in our constitutional system. So who's William Marbury? Well, William Marbury he's a prominent Federalist. So he's an ally of John Adams. He's from Washington, D.C. And in this case, what he wants more than anything is he wants to be a justice of the peace in D.C. So John Adams and the Federalist Congress, they create this position as John Adams is getting ready to leave the presidency. They give this, John Adams signs the commission, they seal it, but ultimately William Marbury's commission is not delivered to him. So then Thomas Jefferson becomes president. The Madison and Marbury Madison is indeed that Madison, the father of the Constitution, that guy, the one that's on the screen right now. And what happens is Thomas Jefferson, who's a Democratic Republican, doesn't want William Marbury, this Federalist, to be a justice of the peace. So Thomas Jefferson basically says to his friend James Madison, you know those commissions on your desk? Just stick them in the drawer and don't deliver them. And so Marbury versus Madison becomes this case where William Marbury is saying, I was given this job, give me this job, Marshall Court. And what John Marshall says is effectively, no, William Marbury, you're not going to have this job. Now, why is this important? This is some well-connected Federalist wanting some job that we don't even precisely these days know what a justice of the peace would do during that period. Why do we care about this case? Well, it's the case that we read as establishing the principle of judicial review, that power of the Supreme Court to decide whether a law is constitutional or unconstitutional. So whether it's a law passed by Congress, a law passed by a state government, it's that authority, that key authority the court has to say constitutional or unconstitutional. So what does John Marshall say in Marbury versus Madison? He says, William Marbury, yes, John Adams signed your commission. Yes, they sealed it. They placed the seal of the United States on it. Yes, you are entitled to this commission, but we, the court, do not have the power to give it to you. How does Marshall get there? Well, he says, William Marbury, you're right. Congress did try to give us this power, but that law that Congress passed, it's unconstitutional. It's unconstitutional, so we don't have this power. Now, why was this a big debate? And I'll end it here, Kerry. Well, if you look in your Constitution, there's no specific mention of judicial review. So John Marshall here in Marbury, the reason we read this case is not because it's the first time that a court uses judicial review in the American system, but it's that Marshall does such a good job of explaining why it is that the Supreme Court and the federal courts have this power. So it's one, in Article 3, the courts are given the judicial power of the United States Two, Article 6 of the Constitution says that the Supreme Court is the supreme, that the Constitution is the Supreme Court, is the supreme law of the land, Constitution, supreme law of the land. And then finally, John Marshall, as a justice of the Supreme Court, as the Chief Justice, takes an oath to defend the Constitution. And so what he has to be able to do is to say, your law here does not square with the Constitution. It's my oath, it's my power to say so, and to say that that law is no law. So that's Marbury.
And I love that line. Marbury, judicial review, what is a law and what is that law is no law. I feel like I need a t-shirt that says that. Next case, because we are going to speed through these. Again, another Marshall case, McCullough v. Maryland. Lay out the facts for us, and I'll put some stuff in the chat as well.
Sure. So this case is broadly about the powers of the new national government. And it tackles one of the earliest constitutional questions in American history. Is it constitutional for Congress to establish a bank, a national bank, a bank of the United States? Now, why is this a question? It's because if you look in your Constitution, there is no clause in Article 1, Section 8 giving Congress the power to establish a bank. So if you're looking at this debate throughout, early American history, you have key figures on each side of this constitutional question. We have Alexander Hamilton saying, absolutely, Congress has the power to establish a national bank. And on the other side, we have figures like Thomas Jefferson and James Madison saying, no, read your Constitution. We just created a national government of limited powers. Where's the power? And so this is a debate that continues throughout early American history. The Washington administration settles it in the cabinet. George Washington sides with Hamilton and allows and signs the bill creating a bank of the United States. But this question, constitutional question, remains, and it comes up finally to the Supreme Court, basically 30 years later. And so finally, the Marshall Court has to say yes or no. Is the Bank of the United States constitutional? Is it unconstitutional? McCullough here is the head of the Baltimore branch of the Second Bank of the United States. And what Maryland's done is Maryland has passed a law trying to tax that bank out of existence. It's a state law that taxes branches of the national bank, trying to destroy it. But Maryland makes the broader argument saying the bank is unconstitutional. What does Marshall say? Well, one, Marshall says, I'll start with the easy one. Maryland, you want to pass that tax to try to tax the Bank of the United States out of existence. You can't do that. Article 6 of the Constitution makes national law, national institutions supreme. The power to tax is the power to destroy, and you as a state government don't have the power to destroy the national bank. But more broadly, to this big question of, does the national government have the power? Does Congress have the power to charter a national bank? What Marshall says is, you have a point. There is no clause in the Constitution, no charter bank clause, no established bank clause, but you're reading the Constitution wrong. The Constitution was written as a constitution. It's meant to be a document that we, the people, can all read. If we listed every little thing, like whether we could establish a bank, he said it would partake of the prolixity of a legal code. Which all that means is it would start looking like the United States statute books or the federal Federal Register with their regulations. The Constitution is going to fit in our pocket. And how do we know this? How do we know that this is the vision? Well, read what Article 1, Section 8 says, which gives Congress its powers. It lists some really important powers: the power to tax, the power to regulate interstate commerce, the power to declare war, all of these big powers. But it also has the necessary and proper clause, which says that Congress also has to have the power to do other things that are necessary and proper for carrying out the powers that are actually listed. What Marshall says is that, therefore, not literally everything Congress is going to do needs to be listed in the Constitution. You can draw a link. We as judges have to be able to look at what Congress did, look at this listed powers in the Constitution in Article 1, Section 8. Is there enough of a connection there? And what Marshall says here is that if you look at Congress's listed powers, the power to tax, the power to borrow and spend for the general welfare, the power to conduct war, it would be really, and then think about what a national bank can do. A bank can be really important for Congress and the national government in carrying out a lot of those responsibilities. And so it's all to say that, it would be possible, and some scholars argue, to read the necessary and proper clause as really requiring a tight connection between what Congress did and the powers listed. And Marshall's saying, I'm going to read it a little more flexibly. Because we need a constitution that's both of limited powers, but also one that allows the national government to do big things like promoting our commercial republic. And the last thing I'll say on McCullough, Kerry, is These debates continue to this very day. We still debate to this very day. How many powers go to the national government? Which powers to the national government? Which powers to the states? It's why McCulloch is such a powerful and landmark case.
Awesome. And I think it's so fascinating that the court is defining the power of another branch as well. A clarifying question from Elise from the Marbury versus Madison. Why didn't he grant it? So Marshall, why didn't he grant the whatever the job was?
It's a writ of mandamus is the technical thing. And so why did he not grant the commission? Well, what Marshall's saying in the end is, I don't have power to do it. So if we're looking at it technically, it's Marbury bringing in something called a writ of mandamus, which is effectively saying court tells someone else in the government to do something. And Marshall's saying that goes beyond the powers that we, the Supreme Court, were allowed to have under the Constitution. So we don't have the power. We don't have the power to give you this commission.
So he's saying, yes, you should have the commission, but it's not my job, and I don't have the power to do it.
And incidentally, it's why so many people look back at this decision as strategically so politically savvy, because it allows Marshall to both attack the Jefferson administration, because he's a Federalist, Jefferson's a Democratic Republican, and so it allows him to do that while also allowing the Jefferson administration to get its way. And just to be clear, Thomas Jefferson was outraged by Marbury. It flew in the face of what he believed the powers of constitutional interpretation even were. He thought that Marshall was taking way too much power for the court, and that we should respect the constitutional voices of each branch of government. So it's an extraordinary case.
I think the soap opera-ness of this case is what I love the most. It's a little like frenemies, and it's like Marshall playing a shell game and really coming out on top and laying out his cards brilliantly. It's
Adams, Madison, Jefferson, Marshall. It's like, could you have a more interesting cast of characters?
I know. You need a scene on Broadway with them in it. Okay, next big bundle that we're going to get to is the premise of equality in the Constitution. And we're going to look at these first big three cases and kind of loop them together. So Tom, can you walk us through this next kind of theme and pillar of constitutional landmark cases?
Yeah, so here we want to tackle the debates over the Constitution's promise of equality. And of course, this is a debate that goes from the Declaration all the way through to today. It's not like it's settled by these cases at all. But what these three cases, Dred Scott, Plessy, and Brown, get to is Dred Scott gives us the most important, most infamous Supreme Court decision on slavery prior to the Civil War. Plessy v. Ferguson gives us a key decision right after Reconstruction that is going to effectively write the Equal Protection Clause of the 14th Amendment out of the Constitution in many ways and allow white Southerners to impose Jim Crow segregation in the South. Plessy is sort of a hinge point there. And then finally, Brown allows us to tell the story of when the Supreme Court, when we, the American people, began to really push for the promise of equality again. Brown being read together with earlier actions chipping away at Jim Crow segregation and Plessy v. Ferguson, and later actions like Civil Rights Act of 1964, Loving v. Virginia, all the way up to later debates over women's equality, LGBTQ rights, affirmative action. A lot of the things that, a lot of the constitutional debates we've seen in the last few decades all are part of this broader debate over what does the Constitution's promise of equality mean?
Awesome. So let's start with Harriet. I always like to start with Harriet because she begins the court case. And Harriet and Dred Scott.
Yeah, so Harriet and Dred Scott, they're enslaved people. They're husband and wife. They have two young children, two young daughters. And you're right, Harriet Scott's the one who pushes for this case. And so what do they have in mind? A very human thing. They know how terrible it is to be enslaved. They don't want their daughters to have to live as enslaved people. And so they bring one of these, we see many during this period, this is 1857, before the Civil War, many enslaved people bringing what are called freedom suits, and they're exactly what they sound like. They're attempts to sue in court for their own freedom. And the argument here for Dred and Harriet Scott is that, the slaveholder had brought them into a free state, a territory where slavery was illegal, and that freed them. And so they're coming to federal court saying, we are now free. Federal courts, respect state courts, and then federal courts respect our rights. And so, what does the Supreme Court say? Well, it's an infamous opinion, and we would say this would be an anti-canonical case, Kerry. If Brown in the end is the canonical case of this series, Dred Scott would be one of the anti-canonical cases. And what does the Supreme Court say? Well, it's the opinions by Chief Justice Roger Brooke Taney. And he says, no, Dred and Harriet, you're wrong. And you shouldn't, you are not free. You are not free because of your actions. But he goes way further than that. He also says that African Americans can't be United States citizens. So you two, you're not United States citizens. Neither are your daughters, neither are any African Americans. They cannot be United States citizens. And that African Americans had no, quote, no rights which the white man was bound to respect. And so it's effectively just completely writing them out of American citizenship and any of the promise of the Constitution. And then finally, he goes even further than that and says that, oh, and by the way, Abraham Lincoln, Republican Party, pushing for freedom in the federal territories and saying that Congress should be able to declare free soil out in the federal territories of the United States. Congress doesn't have that power. That's unconstitutional too. So the Missouri Compromise, which allowed for free states in the territories, unconstitutional. And so it's this three-pronged attack, advancing a slaveholding vision of the Constitution, but it doesn't go unanswered. It doesn't go unanswered. There are two powerful dissents on the Supreme Court by Justice John McClain and Benjamin Curtis. McClain actually resigns from the Supreme Court as a matter of principle, so outraged by Dred Scott. And then, of course, we have the Republican Party and Abraham Lincoln. This is before Lincoln's elected president, but part of the famous Lincoln-Douglas debates, part of the argument there is Lincoln arguing that the Supreme Court got Dred Scott wrong. And so you have a Republican Party that part of their, core arguments are that the Supreme Court got Dred Scott wrong, and eventually through lawful means, we need to reverse it. And that's precisely, just to flash forward. So that's Dred Scott, Kerry. The next phase, the period between Dred. Oh yeah, I'm sorry, Kerry.
Yeah, sorry. Two questions real quick. One from Joan that I really want to clarify, because what Tani writes, and we'll send you this great clip of Justice Gorsuch speaking about this is the worst Supreme Court decision ever. And he breaks it down if you want to dive into deeply. But one point really quickly, when we think about these cases that you're going to see, and they're anti-canonical because they're bad law, they're bad court cases. But what we watch over American history, and Professor Jeffries, who's going to be on next Friday, spoke of this last night in our teacher professional development. We watch African-American enslaved people and African-Americans over time in America pushing and reaching for what the Declaration of Independence has promised, and doing that through resistance, and then doing it like Harriet does through the courts and through the law. And so that is really important. These people fought and fought and fought, even though they know they may never win, but to push it. And that's the theme of all these cases, is how these people in all different time periods, all different people, you have used the courts to fight for rights and individual rights for all of us. So it's really important we remember it begins with we the people. And Joan's question was this. So Tani's comment about not a citizen, does that apply to just enslaved people? Does it apply to free people? Does it apply to new immigrants, say, coming from Kenya?
Yeah, I mean, it's broadly, it's not just enslaved people. It's saying what he does, and this is what's the flashpoint between Tawney and the dissenters, is he looks at American history, goes back to the Declaration, to the Constitution, et cetera, and says, what is the status of African Americans, not just enslaved people, but African Americans in the United States? And he is effectively saying they cannot lay claim to the promise of American citizenship. And that's precisely, you're right, Kerry. What's amazing about Dred Scott and Dred and Harriet Scott and all of the other African Americans battling for citizenship before and after this case is that after the Civil War, we write the promise of equal citizenship into the Constitution. It's not that Dred and Harriet Scott aren't heard. It's not that other African Americans laying claim to citizenship, equality, and liberty aren't heard. They are heard. And what we do after the Civil War, through the 13th Amendment, we abolish slavery, but through the 14th Amendment, we promise everyone born on American soil, they're a United States citizen, no matter, race or anything else. And so that's a broad principle we have there. And then we write the Declaration's promise of freedom and equality right there in the Constitution. And so you're right, Kerry. There's a way in which history bends over time. We don't want to be too romantic about it, but there's a way where once we write it into the Constitution, it's not just, it becomes less abstract. It's right here. And you could go to court and say it's right here, and we can get into Plessy if we want.
Yes, I was going to say that's perfect for Plessy, because even though we write it into the Constitution, what I always say is like the promise of equality and freedom and so many individual rights, it's not really like a bending towards progress. It's more like a hard push by people, but with huge setbacks. And that was, again, something we talked about last night, is you get these forward motions and this pushback. And people like Plessy trying to do what they can to have a forward motion and fight for the rights that are in the Constitution. So tell us about Plessy.
Yeah, so Homer Plessy is a citizen of Louisiana. He's an African-American. And, he's at this interesting period in Louisiana. So one thing to remember, and Kerry's totally right, is that there is this period of promise in American history during the height of Reconstruction, where we write these promises into the Constitution. We even live them. We live them in many states, most notably in many ways, Louisiana, where we have African Americans in state legislatures, as governor, as members of Congress. And so we do try out this experiment in interracial democracy, and for an all too brief period. It actually works all the way from the top, all the way down to sheriffs of local parishes in Louisiana. But what we're seeing here, less than 30 years after the ratification of the 14th Amendment, is a huge backlash against this. And so Plessy is about that. Homer Plessy is that Louisiana has passed a separate car act of 1890. And what this says is that rail cars in Louisiana need to have separate cars for white passengers and African-American passengers. And Homer Plessy is he's part of a group of concerned citizens looking to challenge this law. He himself he's African-American, but he has a lighter skin tone. So if he were to go, and he's going to go onto a white car and challenge this law by his very action. And what Plessy's thinking is that if you were to just look at him, you wouldn't know if he were white or black. And so it would be very hard for anyone to make that decision. And what he's trying to show is that this law itself is unjust. It's arbitrary. And so he's challenging this law as really not living up to the promise of the 14th Amendment or the height of Reconstruction, where we tried to do interracial democracy. And what does the Supreme Court say? So we look at this case and it's like, it's so clearly seems to violate equality. How could the court go along with this? But it's a 7-1 decision saying that, Plessy, you're wrong. Louisiana's right. A law like this is constitutional. It doesn't violate the 13th Amendment and its promise to abolish slavery. It doesn't violate the 14th Amendment and its promise of equality. It is within the core powers of the state, those traditional powers of the state, to promote the health, safety, and welfare of their citizens, to pass a law like this. And then the justice there who wrote the opinion, Justice Henry Billings Brown, went on to have the audacity to say, if you, Homer Plessy, or you other African Americans in Louisiana, if you look at this as a badge of inferiority, that's on you. The law doesn't say anything about that. In reply, and in many ways, the opinion we remember most is the dissent in this case. They're the one. It's 7-1. Who's the one? It's Justice John Marshall Harlan. He himself, from an old slaveholding family, opposed the 13th Amendment, opposed the 14th Amendment, but Reconstruction changed him too. He saw the violence against African Americans in the South. He saw he saw so far too many people not living up to the promise of the 14th Amendment, and it changed him. And so here, what he says effectively, Kerry, is, majority of the Supreme Court, what are you talking about? How can you not look at this law and see it for what it is? It's branding African Americans with second-class citizenship. That can't work under the 14th Amendment. It's unconstitutional.
Yeah, and The Great Dissenter is the book I just got, and I can't wait to read it. It's the next on my reading list. But it is an amazing piece to read, is that full dissent by Harlan. So next court case, and now starting to come into forward movement, and again, ebbs and flows. Now we're moving back into this court case. So Brown versus Board of Ed, 1954.
Yeah, so we're 60 years later, basically, and it's Brown versus Board of Education. Who is Brown? It's Linda Brown. She's a third grader. And what does she want? She wants her local school district in Topeka, Kansas, to let her go to her local school, the Sumner School. And Kansas says that only white children can go to this school. And she challenges it, saying that, no, that violates the Constitution. That's unconstitutional. Now, this is part of a range of challenges that are brought together in Brown versus Board from different school districts throughout the country. So we have Kansas, we have a school district from South Carolina bringing in the Deep South. We have school districts in Delaware and the District of Columbia. And so we have a range of districts from across the country, but all of the children, what they're doing is saying, we want to be able to be educated in schools where everyone's treated equally, and we don't have separate systems for white students and African-American students. Now, for the Supreme Court, this raises a real constitutional question. Was Plessy versus Ferguson right? Was it right or was it wrong? And so leading up to Brown doesn't come out of nowhere. Brown is the result of many years of advocacy by the civil rights movement itself, but also key lawyers like in the NAACP, Thurgood Marshall, bringing challenges to different Jim Crow segregation laws, trying to get the court to recognize them as unconstitutional. And so it built up to Brown, getting the court to say, no, you can't, segregation is a problem in law schools. It's a problem in higher education. Now, finally, the court has to address the question: is it a problem in public schools? And the court, in a unanimous decision, says that segregated public schools are unconstitutional. Plessy was wrong. The Constitution's promise of equality requires that there not be separate school systems for white children and African Americans. That separate but equal, which Plessy said was okay, is inherently unequal. Even if you made the schools equal, which we never did, but suppose even we did, the separation alone violates the Constitution's promise of equality.
And I think Warren made a great point earlier, but equality rests with an act by Article 1 solution. Amendment, not just Article 3 solution. And I think it's a great point here because the courts come down with this in 1954, and it isn't until about 10 years later that we see real desegregation of the schools happening, correct?
Oh, absolutely. And you're right, Warren. Brown ends up eventually, and the civil rights movement beget things like the Civil Rights Act of 1964, expanding the promise of equality to a bunch of different places, the Voting Rights Act of 1965, Loving v. Virginia in 1967, declaring bans on interracial marriage unconstitutional, and on and on. And as we sort of said at the beginning, Kerry, and the debate over equality continues. It continues. It's every term at the Supreme Court, in our politics, everything, because we begin with the Declaration's promise of equality, and we fight about it through our entire history.
Awesome. Okay, next theme we're going to jump to is the Bill of Rights. And we're really going to focus on West Virginia v. Barnett on this one. And again, all these cases are in your briefing packet, so you have all of them. You can dive into MAP, which I love the story of MAP. Not love it, but I find it so interesting. So West Virginia v. Barnett.
Sure. So now we're rewinding to World War II. And so here you see students in a classroom saluting the flag. And the key question here is, can school districts, can states force students who have religious objections to salute the flag? And what's the penalty if they don't? Expulsion. Can they be kicked out of school for following the dictates of conscience? And so we might say, well, if our First Amendment means anything, it must mean freedom of conscience. Surely it must give students protection. But West Virginia v. Barnett is in 1943. There's a case just 3 years earlier in 1940 called Gobitis, where the court said effectively it's okay to require students to salute the flags, and it's okay to expel students who refuse to do it. Now, why would anyone ever say this? Well, remember the context. That's 1940. We see in the late 30s and early 40s a push to have our schools promote patriotism in the run-up to World War II and during World War II. And part of that expression of patriotism was seen to look at the flag as an important national symbol to respect. And we thought schools were playing that important role of promoting patriotism. And the Supreme Court, in an 8-1 decision, said that these flag salutes are constitutional, and it is also constitutional to expel students who refuse to salute because of religious objections. Now, who were the Gobitis children and who were the Barnett children? They're Jehovah's Witnesses. So what Jehovah's Witnesses, one of their core tenets is that there is no higher law than God's law. And that as a result, they can't pledge and honor the way many other students would man-made law or governmental law. So they can't do something like pledge the flag of the United States. And so with this, after Gobitis, we see tragedy, Kerry. I mean, real tragedy. Gobitis then begets violence against Jehovah's Witnesses. Jehovah's Witnesses are seen as unpatriotic as we're fighting World War II. And so we see great suppression, great violence, and amazingly, in 3 years, the Supreme Court reverses course in West Virginia v. Barnett. And it says, you know what? We got it wrong in Gobitis. There's this amazing concurrence in West Virginia Barnett by Justice Black and Justice Douglas, two of the great civil libertarians on the court, who went along with Gobitis and said, we were wrong there. We changed our minds, and now we see that these flag salutes, this punishment of expelling these students is unconstitutional under the First Amendment. Now, Kerry, these students are young. They're young. They're what, 8 years old, 11 years old? They're being expelled from school. They're facing threats and actual violence outside of school, many of these students. It took real bravery, real courage to go there to go to school in front of all of their classmates, in front of their teacher, refuse to salute the flag, and to stand with their First Amendment principles here. And it ends up, not surprisingly, in such a human case, it creates some of the most memorable lines in the history of Supreme Court decisions, and really one of the strongest expressions ever of the First Amendment's commitment to free expression, freedom of religion, and freedom of conscience. And what we see in Barnett, it's a majority opinion by Justice Robert Jackson, who he himself was, a former Attorney General and Solicitor General under FDR, but also one of the great writers in the Supreme Court's history, expressing why is it that what is one main reason we have a Supreme Court, and why do we have a Bill of Rights? Well, it's to protect the unpopular. It's to protect people, Oliver Wendell Holmes would say, who express speech that you hate, but it's to protect the Jehovah's Witness student who cannot salute the flag because of their conscience. And what we see across a range of cases is a bunch of different religious dissenters making important constitutional law, making important contributions. It's the Amish in a case called Yoder. It's practices of the Santeria faith in a case called Lukumi. But in each case, what Jackson's explaining here in Barnett is that the Supreme Court is there to protect the unpopular people who might be oppressed by the majority. And that's also why the Bill of Rights is there. And so the Supreme Court's role in the Bill of Rights coming together to protect freedom. In this case, for the First Amendment, we would see this commitment expand in decades afterwards. Because again, if you study American history, you realize the court wasn't always so good at this. It didn't always protect the dissenter. It didn't always protect the unpopular. But we do see a greater commitment to it from the period of Barnett all the way up into the 50s, 60s, and onward.
I'll just nod to Whitney on that last comment. If you want to look up the Whitney case, that's a good one to read too. Okay, our last and final case, which I think is a really important one, is Korematsu. So real quick, you got like 2 minutes here. Give us Korematsu.
Okay, so let's begin with Fred Korematsu. He's a 23-year-old. He was born to Japanese immigrant parents. He himself was born in California. So he's a Californian. He's an American citizen. And this case takes place, the facts of the case take place during World War II. And so FDR issues an executive order saying, what we need to do is we need to create internment camps, and we need to round up people of Japanese descent and place them in there. We're concerned, we're fighting a war against Japan. We're concerned about Japanese spies, whether they're whether the people that we're rounding up are American citizens or not. We need to round them up, and we need to keep them all in one place so we can keep tabs on them. And so, to us today, we'd say, how in the what? Can I count the number of constitutional provisions this seems to violate? I mean, it just seems like what could be more anti-canonical than Korematsu? What could be a better example of this has to be unconstitutional? But the court, in a 6-3 decision, says, no, FDR's executive order, it's constitutional. And they make the arguments that you would kind of expect. We would look back at it and say, well, it's the Supreme Court issuing a decision in the fog of war. And I think there is something to that. It was a time of great national peril. And what the Supreme Court majority says in an opinion by Justice Hugo Black, who again, in many ways ends up being such a key figure on so many constitutional liberties. But in this one, he says, look, we're fighting a war. Congress gave the president a great deal of power to conduct this war in the way the president deems fit. And, in the end, the president's chosen this is what we need to do for national security. There seems to be, we're not going to second guess that decision. But remember, there are 3 powerful dissents in this case. One by Justice Murphy, who calls out the executive order and what happens here. What does he say? He says we descend now into the ugly abyss of racism. So it's Justice Murphy really bringing in that powerful language. We have a dissent by Justice Owen Roberts, who he himself likens the internment camps to concentration camps. So what Owen Roberts is saying in his dissent is, what are we fighting World War II for if we send Fred Korematsu and so many other people into internment camps? And then finally, Justice Jackson in dissent, again, he was FDR's Attorney General, says that I can understand the need for national security, but what you're doing here is you're placing a loaded pistol in the hand of the national government. Anytime the government now can make an argument that there's an emergency, there's national security, is this just a green light to throw the Constitution out the window? That's a terrible precedent. And so those are the dissents. The last thing I'll say, just a brief coda on Korematsu himself. So he loses this case before the Supreme Court, but he doesn't give up. He continues for decades and decades to fight for justice. And what does this result in? One, eventually victims of internment camps get reparations from the national government. Mm-hmm. Two, Korematsu, decades later, gets a federal court to throw out his conviction, saying there was prosecutorial misconduct. And finally, Fred Korematsu himself gets the Presidential Medal of Freedom. And so it's again an example of the fight doesn't end at the Supreme Court. If you think the Supreme Court got something wrong, you can continue to use advocacy, continue to bring cases, and continue to lay claim to the United States Constitution.
And one of the things that I found so heartbreaking and also so uplifting was right before the 83 case, when they threw it out, he was just about to lose hope. And he said, his comment was, I feel like I've been orphaned, that I have no real home. And he doubled down and goes forward. And that's when they find the new evidence. And that's when they see what happens. And this unbelievable flip. And so it's unbelievable watching these court cases, been remembering all these people and how hard they've struggled to make change, and to remember these cases and these great people.
And remember, it does it to a certain extent just to bring it back to Marbury. If you read from Marbury to Barnett, it's this idea of carving out a role for the Supreme Court, that the Supreme Court justices, they're not elected, they have insulation from politics, and to be able to, gives them the power and the flexibility to sometimes speak out and to protect the constitutional rights of the unpopular. That's one of the great justifications for judicial review.
So Sean Kelly asked this question: could someone use this case as evidence for African Americans to get reparations? And that's when I was reading the brief last week or wherever it was, I was thinking the same thing. Is there some way to use the precedent here in a case for reparations for enslavement?
I think people would use it as part of the political. I think it's more of the political case than any sort. But yeah, I would imagine that would be part of the argument, saying that the national government has done reparations before, and here's an example. You would imagine that being, as with everything, being able to cite historical examples often strengthens people's arguments.
Absolutely. And Warren pointed out, fast forward, and was referencing the Muslim ban, which I dropped kind of a little blurb in the chat about. But remember, everybody, because I know we have to wrap up now, there is a ton of information in that document, and all the court cases in each of these sections have great descriptions in them and kind of key takeaways and great quotes. So Tom, I want to thank you so much for class today. This was really fun, and it did fly by in all these cases, and some really powerful stories to hold on to.
Excellent. Thanks so much, Kerry. I tried to get through it as fully as I could.
Where's the briefing document? Great question. I will share the link again, and I'm going to stop the recording real quick. So